Chapter 8 of the South African Law of Persons, 6th edition by Jacqueline Heaton. The topic of Chapter 8 is inability to administer affairs owing to reasons other than mental illness. Under Chapter 8, we have 8.1 Introduction, 8.2 Applying to have a curator appointed for a person who is unable to administer his or her affairs, 8.3 Legal status of a person who is unable to administer his or her affairs. These topics are covered from pages 133 to 135. Just before we continue, thank you so much for listening. Please take a few seconds to like this video and previous videos if you found them helpful. And please also subscribe to our channel, The Helpful Voice. 8.1 Introduction. In the previous chapter, it was explained that the High Court has the power to appoint a curator or administrator to a mentally ill person. In terms of our common law, the High Court also has the power to appoint a curator to a person who is not mentally ill but is incapable of managing his or her affairs for another reason, such as physical or intellectual, that is mental disability. See footnote 1. The objective of the appointment of a curator to a person is to protect the person from exploitation. Because the status of a person who is subject to curatorship is restricted, the courts are hesitant to appoint curators. See footnote 2. As Judge Bleeden pointed out in Juden v. Wedgwood, see footnote 3, to appoint a curator to a person without full justification, therefore, constitutes a serious violation of that person's dignity and status, which is contrary to the provisions of Section 10 of the Constitution of the Republic of South Africa. See footnote 4. Appointing a curator to a disabled person without sufficient justification also violates Article 3, subsection A of the Convention on the Rights of Persons with Disabilities, which requires states parties to respect the inherent dignity, individual autonomy, and independence of persons with disabilities. See footnote 5. South Africa ratified this convention in 2007. Unjustified appointment of a curator further constitutes unfair discrimination on the ground of disability, which violates Section 9, subsection 3 and subsection 4 of the Constitution and Articles 3, subsection B, 4, subsection 1 and 5 of the Convention on the Rights of Persons with Disabilities. See footnote 6. 8.2 Applying to have a curator appointed for a person who is unable to administer his or her affairs. The court gives a liberal interpretation to the categories of persons who can be placed under curatorship. For example, curatores bonis have been appointed to persons unable to manage their affairs as a result of a serious illness or the after effects of a serious illness, physical or intellectual disability, persons who have disappeared and in respect of whom a presumption of death has not been pronounced, and persons residing in an enemy country during war. Please see footnotes 7, 8, 9, and 10 respectively. A curator bonis has also been appointed to a prisoner of war. See footnote 11. And if you can just track back here, where we previously described or defined curator bonis. A curator bonis is a court-appointed legal representative in South Africa responsible for managing the financial and property affairs of someone who lacks the capacity to do so themselves, typically due to mental illness, disability, or dementia. So, just as a matter of interest, the term is derived from the Latin meaning curator of goods, in quotes. This role specifically focuses on financial matters and property oversight, distinct from a curator ad personam who handles personal care, or as we learned earlier, who handles body, basically. Advanced age sometimes causes serious illness and physical or intellectual impairment, which may result in the need to appoint a curator. See footnote 12. Due to aged persons frequently being more vulnerable, the Older Persons Act 13 of 2006 lays down general principles which must guide the implementation of all legislation and all proceedings, actions and decisions by an organ of state regarding an older person or older persons in general. See footnote 13. The provisions of the Act extend beyond the appointment of curators. In many respects, the principles embodied in the Act echo those that are laid down by the Children's Act 38 of 2005 regarding minors. See footnote 14. Thus, for example, the Older Persons Act stipulates that all proceedings, actions, or decisions in a matter concerning an older person must respect, protect, promote, and fulfill the person's rights and best interests, and the rights and principles set out in the Act respect the person's inherent dignity, treat him or her fairly and equitably, and protect him or her from unfair discrimination on any ground, including his or her health status or disability. See footnote 15. An approach which is conducive to conciliation and problem solving must be followed in any matter concerning an older person, and a confrontational approach must be avoided. See footnote 16. Furthermore, a delay in any action or decision must be avoided as far as possible. Footnote 17. The Act also deals with abuse of the elderly. Check footnote 18. Apart from appointing a curator bonis, the court may also appoint a curator personae and or a curator ad litem for a person who is unable to manage his or her affairs. See footnote 19. Although the court is not compelled to appoint a curator to someone who consents to the appointment, consent is an important factor in deciding whether or not to place the person under curatorship. See footnote 20. For any weight to be attached to the consent, the person must be able to understand the nature and effect of the proceedings to place him or her under curatorship. See footnote 21. If the person is unable to understand the nature and effect of the proceedings, a curator ad litem must first be appointed to represent the person at an inquiry into his or her mental state. The court does not regard it as proper that a person personally apply to be placed under curatorship, because if the person is in fact incapable of managing his or her affairs, he or she may lack locus standi in judicio to make the application. Therefore, a family member or someone else who has an interest in the person's person or property has to make the application. See footnote 22. The court in whose area the person is domiciled or owns immovable property has jurisdiction to declare him or her incapable of managing his or her affairs and to place him or her under curatorship. See footnote 23. Before we get on to our next subtopic, I just thought it would be interesting for us to summarize the curatorship that we have learned about and define it. So we have curator bonis, curator ad litem, and curator personae. So a curator bonis, remember, as in the previous chapter we have defined it as a Latin word for curator of goods. So practically, this guy is appointed by the High Court to manage financial affairs and property for a person due to their mental and physical incapabilities. So if we hear of a curator bonis, that dude is there for money and property to manage that. And a curator ad litem is appointed by the court for someone who cannot represent themselves in court proceedings. And then we have a curator personae, which is a court-appointed guardian responsible for the personal welfare and care of an incapacitated adult. So this person makes decisions about their health care, their living arrangements, and their general well-being. So again, curator bonis, that dude is there to manage financial affairs and property. Curator ad litem, that person is just there to present someone who can't do it themselves in a legal proceeding. And then a curator personae is someone who is there as a guardian who makes decisions regarding healthcare, living arrangements, and general well-being. I thought that would be helpful just to summarize it like that. Let's move on. 8.3. Legal status of a person who is unable to administer his or her affairs. A person who has been declared incapable of administering his or her affairs and to whom a curator has been appointed has the capacity to conduct his or her affairs whenever he or she is in fact mentally and physically able to do so. In other words, the fact that a curator bonis has been appointed in respect of a person's estate does not mean that the person has been deprived of capacity to act and litigate. Nor does it mean that the person is incapable of being held accountable for crimes and delicts. See 24 and 25. In PNR versus PNR's curator, see footnote 26, Judge President de Villiers stated as follows. Here again, the curator is merely appointed to assist the person in making legal dispositions insofar as such assistance is necessary, according to the nature of the incapacity in question. But the person still retains his contractual and legal capacities and administration of his property to the full extent to which he is from time to time mentally or physically able to exercise them. Accordingly, someone who has been placed under curatorship because of inability to manage his or her affairs can enter into a valid legal transaction with its normal consequences if, at that particular moment, he or she is physically and mentally able to do so. Thus, for example, it has been held that such a person may marry without his or her curator's consent, whether in or out of community of property, make a will, enter into a contract, and litigate. Please see respectively footnotes 27, 28, 29, and 30. If it is found that the person lacked the capacity to understand the nature or consequences of a particular transaction when he or she entered into it, he or she is not bound by the transaction and the transaction is void because of lack of capacity. See footnote 31. Consequently, The person's capacity to enter into valid legal transactions may differ from day to day, but remains a question of fact. Since a person who has been placed under curatorship due to a disability does not lose his or her capacity to litigate and can enter into a valid legal transaction whenever he or she is able to do so, the current legal position probably does not violate Article 12, Sub-Article 2 of the Convention on the Rights of Persons with Disabilities. This article obliges states parties to recognize that persons with disabilities enjoy legal capacity, in quotes, on an equal basis with others in all aspects of life. Whether the current position complies with Article 12, Sub-Article 3 to Sub-Article 4 is less clear. These sub-articles require states parties, inter alia, to take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity, in quotes, and to ensure that measures relating to the exercise of legal capacity respects the rights, will, and preferences of the person, in quotes. Currently, a curator's decisions replace those of the person who has been placed under curatorship unless the person is in fact able to make decisions in the particular field. For example, a curator personae makes decisions on the person's person whenever the person is unable to do so. It may be that this substituted decision-making does not fully comply with Article 12. See footnote 32. And this is the end of Chapter 8. In our next chapter, Chapter 9, our topic will be about the influence of alcohol and drugs. Hey there, thank you for listening. If this was helpful to you, please take a minute to subscribe, like, comment, and share.